Hi, my name is Perez-Roura. I'm an estate planning attorney here in Miami, Florida. This is video number 3 in a series of 4 videos discussing the overall aspects of estate planning. So if you have not watched videos numbers 1 and 2, I would invite you to watch them first so that this video will make much more sense. So as described in video number 1, we break down estate planning to 3 primary questions. This video is about question number 2, which is while I'm alive, if I mentally am not able to make decisions for myself, well, who can make medical decisions for me? Or do I want to make some decisions ahead of time? Right? As to the first part of that question of who can make medical decisions for me, I can choose whoever I want, right? At least 18 years old, right, to make medical decisions for me. Right? And it doesn't have to be just one person. I can name a series of people. So, first, person number 1, and if they can, then person number 2, if they can, person number 3. And there really is no limit as to how many people we can name. Or we can say, well, I want these 3 people to make decisions, at the same time. Now, if we do that, if we name more than one person at a time, then it brings up some additional questions, such as, do they have to, agree unanimously? Right? Do all 2, 3, 4, 5 people that we've named, do they all have to agree? Is it by majority? Can any one of them just decide? That can necessarily create more problems than it solves, right? So typically, my recommendation is name one person at a time, right? That way it's much more clear, and basically everybody else after that, you've told them that this is who you want to make decisions for you. So that's generally my recommendation. Now, with that, if you're giving somebody the authority to make decisions for you, obviously they need access to the medical information. So within that designation of healthcare surrogate, that's the official name of the document, we do have language regarding information. It's sort of a HIPAA release, but we also have a separate document that deals directly or solely with that information. Why do we have 2 separate documents? Really for 2 reasons. First of all, maybe you want to name more than one person or authorize more than one person to receive that information, regardless of whether they're making or in that line of people that can make decisions or not. Right? So that's reason number 1. And then reason number 2 is also, just in case, families at the hospital, right? And, in order to speed up the process, right, you give both forms, right? Some hospitals will have different people reviewing the records department will review the release information, and people on the medical staff will review the healthcare surrogate. So having those 2 separate documents could speed up this process. You can also make some decisions ahead of time. And really what we're talking about there is, really the worst of the worst situations, some end-of-life decisions, right? And the official name of this document is a living will. Now, a living will tends to apply really to 3 situations, right? Just start off with, all of them require, it always starts with, if a person is unable to make decisions for themselves, right? If you can make decisions for yourself, then doctors, hospitals, they're going to listen to you and your decision. So even the healthcare surrogate and the living will, these really only apply if you cannot make decisions for yourself. So now the 3 primary situations that a living will deals with. First one I always talk about is a persistent vegetative state. So somebody is, in a vegetative state and they're not going to improve. The second one is they have an end-stage condition, which is, they have some kind of disease that has really run its course and it's in its end stages and will cause death. And the last one is, it's a terminal condition, which is very similar to the end-stage condition. It's just earlier in time. It's some kind of disease or condition that, if left untreated, will eventually cause passing. Now, oftentimes, we recommend to do both, designating a healthcare surrogate and having a living will, should our clients wish to do that. And why would we recommend both? Well, those end-of-life decisions, some people feel very strongly one way or the other about things, and so that's that's a person's way of communicating to the family, right, and really deciding for themselves what they want. And it's making it so that the people we've named in the healthcare surrogate, which are typically the people closest to us, they don't have to live with that decision of either ending, treatment and resulting in ultimately one passing, or even deciding to do treatment and then living with, well, what if it doesn't work? So doing both is generally recommended. And again, the most important thing to remember is, even if you sign these documents, so long as you can make decisions for yourself mentally, you're able to, your doctors, hospital will listen to your decisions. So that wraps up this video. The next and final video deals with, well, similar situation, but the financial aspects.